Cardi B is taking action to try to ask the bankruptcy court to throw out the Chapter 11 bankruptcy of a YouTuber who owes her $3.8 million. So, friends, before we hop into this new filing from this month in the Cardi B lawsuit and kind of never-ending saga that's been going on between her and a YouTuber who the court did enter a judgment against for $3.8 million, please look in the description of our live stream and you'll see that we have actually covered this story years ago when Cardi B actually was awarded the judgment by the court in this case. And that video, which is linked in the description box below, gives full details about that lawsuit. And it's really important, I really think it's really interesting actually that you go back and kind of look and see how this litigation all began. This YouTuber was speaking very derogatorily about Cardi B, and Cardi B took action in a lawsuit. So now here we are where the court has already entered a judgment against this YouTuber for $3.8 million. It was a jury trial, and now this YouTuber has already filed a Chapter 11 bankruptcy case to try to avoid having to pay Cardi B the money that she owes Cardi B. So Cardi B is asking the bankruptcy court to dismiss the Chapter 11 bankruptcy so that she can get her money from this YouTuber who owes her. And she opens up her lawsuit by saying, the bankruptcy code is designed to provide relief to the honest but unfortunate debtor. However, the debtor in this case is neither honest nor simply unfortunate. Her actions, both before and during the bankruptcy case, exemplify fraudulent intent, bad faith, and abuse of the bankruptcy process. And if you watch the original video that we did on this litigation, which is linked in the show notes, you will see that this YouTuber, when she was saying these very unfortunate things about Cardi B, she even said, well, go ahead and try to sue me. Things like, you're not going to get any penny from me because I'm going to just file for a bankruptcy. So this YouTuber was being very verbose and very out there about the fact that she was going to try to avoid having to pay Cardi B any judgment. So Cardi B's complaint goes on to state that following her loss in the defamation action and in direct defiance of the Federal District Georgia Court's explicit admonition not to transfer assets or otherwise impede the collectability of the amended defamation judgment, the debtor and her husband, Mr. Keeb, orchestrated a months-long scheme to hinder, delay, and defraud Ms. Almanzar's collection efforts. Specifically, debtor and her husband engaged in the following conduct: fraudulent personal asset and income transfer. They transferred certain assets and income streams to her husband. The debtor transferred certain assets and income streams to her husband and or his business, Yellen Entertainment, LLC, to hinder, delay, and defraud Ms. Almanzar's collection efforts on the amended defamation judgment. Fraudulent business asset and income transfers. Keeb Studios, LLC, a business jointly owned by debtor and her husband at the time of the defamation action, transferred its assets and income streams to Yellen, which operates as a mere continuation of Keeb Studios without any ownership interest held by debtor. These transfers were executed with the express intent to hinder, delay, and defraud Cardi B, Ms. Almanzar's efforts to collect on the amended defamation judgment. This scheme was specifically designed to shield the debtor's income and assets derived from Keeb Studios and to circumvent the $500,000 judgment against Keeb Studios outlined in the amended defamation judgment. Untruthful and misleading bankruptcy filings and testimony. The debtor filed bankruptcy schedules under penalty of perjury that omitted and or misrepresented certain of her assets and overall financial condition. She knowingly and fraudulently concealed assets, made false statements under penalty of perjury, or withheld recorded information related to the property or financial affairs of a debtor, and that is a federal crime subject to fine or imprisonment of up to 5 years or both. Here, The debtor and her husband repeatedly provided knowingly false testimony under oath regarding the reasons for transferring certain assets to her husband. For example, the debtor's transfer of her ownership interest in the residential home located at 398 Dunlevin Manor Walk in Lawrenceville, Georgia, the Georgia property, was transferred to her husband. They also provided knowingly false testimony regarding the existence, ownership, and control of undisclosed partnerships and onshore and offshore trusts, and misrepresented the business and financial relationships by and among debtor, her husband, Keeb Studios, and Yellen. For example, Mr. Keeb testified untruthfully that Yellen is owned 50-50 between him and his brother, Lassana Keeb, who resides in Mali, Africa. Mr. Keeb further testified neither he nor his brother have ever taken a distribution from Yellen. In fact, Keeb's tax returns clearly reflect Mr. Keeb owns 100% of the interest in Yellen, and Yellen's tax returns also show that Mr. Keeb has in fact received distributions as the 100% owner of Yellen. So Cardi B's attorneys are pointing out that they feel that the representations and the testimony that has been given by the YouTuber debtor's husband does not align with information in the tax returns. Worse, the debtor's plan furthers the lie that Yellen is owned 50-50 between Mr. Keeb and his brother. Thus, Mr. Keeb and debtor are either lying to the Internal Revenue Service or to this court as to the true ownership of Yellen. Crucial, it was only after the claimant, at significant expense, uncovered the concealed trusts and partnerships that the debtor belatedly amended her schedules and disclosed their existence in her amended plan. Debtor's post hoc, self-serving justification for this concealment is not only implausible, but also fails to address and does not cure the fraudulent concealment of the trusts and partnerships from debtor's schedules or the repeated false testimony denying their existence. Notably, the debtor spent over $25,000 to establish the offshore trusts. Debtor's bad faith in filing for bankruptcy is further evidenced by her acknowledgement that she knew prior to filing for bankruptcy that the amended defamation judgment is non-dischargeable. It is black letter law that a judgment arising from an intentional tort involving willful and malicious injury, such as the amended defamation judgment, is not dischargeable in bankruptcy. Despite this, both debtor and her husband repeatedly testify under oath that the primary purpose of the bankruptcy filing was to obstruct the claimant's collection efforts. This was one of the few points of consistent testimony between debtor and Mr. Keeb. So that doesn't quite make sense, that they would testify like that, to say that, yeah, we basically moved these assets around in order to try to obstruct Cardi B from getting her $3.8 million that she has a judgment for. Quite frankly, that would not be the type of testimony to give in a bankruptcy proceeding, that you were trying to evade having to pay a debt that you knew was non-dischargeable. So Cardi B's attorneys go on to state that debtor's bad faith with respect to plan negotiations, further demonstrated by her and her counsel's conduct during negotiations over the financial terms of the Second Amendment plan. The court may recall the following representation that was made by debtor in her motion to continue the confirmation hearing filed on October 30th, 2024. The debtor and her largest creditor, Balkalis Marlenis Almanzar, also known as Cardi B, has reached an acceptable resolution of the matter. However, they continue to work on the specifics to be included in the debtor's yet to be filed amended plan of reorganization, and the parties are concerned that there will not be sufficient notice of the amended plan to all creditors prior to the scheduled confirmation hearing on November 19th, 2024. It has since become evident that the debtor intentionally and repeatedly misled Ms. Almanzar, the subchapter 5 trustee, and the court at significant expense to Ms. Almanzar. Following a judicial settlement conference with Judge Hyman on June 14, 2024, and a subsequent meeting at the offices of debtor's counsel on June 24, 2024, that was attended by the debtor, Mr. Keeb, and his counsel, Ms. Almanzar's counsel, flying in from out of state, the undersigned, and the Subchapter 5 trustee. The parties came close to agreeing on the required plan payments, though further negotiation was necessary. So basically, Cardi B's attorneys are saying, we've been in negotiations with this alleged debtor. We've been trying to reach an agreement for acceptable repayment terms, and now she's continuing to try to evade paying Cardi B. On August 22nd, 2024, the debtor's counsel tentatively agreed to Cardi B's proposed monthly payment amounts contingent on the debtor's approval. A counterproposal from the debtor's counsel was received and accepted by Cardi B on September 9th, 2024. This agreement was reflected in drafts of the second amended plan that was circulated by debtor's counsel on and after November 19, 2024, which included the agreed upon payment schedule. However, on the day the second amended plan was due to be filed, debtor in bad faith unilaterally altered the agreed upon monthly payments in the second amended plan that was filed and further cherry-picked out certain critical protections from creditors that also had been previously agreed between the parties. Debtor's true intentions were revealed when the debtor's counsel informed the undersigned that the plan payment terms were merely aspirational and that no formal agreement had ever been finalized. Debtor's position is not only demonstrably false, but also puzzling for two reasons. One, the total amount to be distributed in the plan payment schedule remains identical to the total amount set forth in the earlier draft that incorporated the agreed upon payment schedule. And two, while payments to unsecured creditors are reduced in the first year, they are consistent with the agreed terms in years 2 and 3 and increase in years 4 and 5 when the projections are most speculative and unsupported by historical evidence. Given these facts, it's difficult to understand how the debtor can now disavow the agreed plan payment schedule as merely aspirational. If the schedule was aspirational before, it remains so now, especially since the feasibility of the plan still hinges on several speculative factors, and these speculative factors include the following. So, the Yellen contribution totaling roughly 3/4 of the funds available for plan payments, assumptions that the debtor will, quote, be able to increase her ticket prices over time, and the production of additional content by debtor. So Ms. Almanzar, also known as Cardi B, was prepared to accept the risk of debtor defaulting under the agreed upon plan payment schedule only on the condition that the safeguards or guardrails that she proposed were fully incorporated into the plan. Ms. Almanzar reasonably believed this was the case, as the guardrail provisions appeared in successive drafts of the second amended plan. However, the filed version of the second amendment plan reveals that many of these critical protections were selectively removed without the knowledge, consent, or agreement of Ms. Almanzar. This demonstrates that debtor had been engaging in bad faith negotiations, misleading Ms. Almanzar throughout the process at tremendous temporal and financial expense. Finally, as will be detailed in a separate objection, in addition to debtor being unable to meet her burden to satisfy the good faith requirement of the federal statute, her plan confirmation, the Second Amendment plan, is facially unconfirmable. It's highly speculative, misrepresents the debtor's income and expenses, and perpetrates the long-running fraudulent scheme to shield the debtor's assets and income from creditors, particularly from Ms. Almanzar, also known as Cardi B. In light of the totality of circumstances, Ms. Almanzar respectfully requests that the court find the debtor's petition was filed in bad faith and enter an order dismissing the bankruptcy case with prejudice, imposing a 2-year ban on refiling under any section of the bankruptcy code. She then alleges that jurisdiction is proper, which is a pretty standard section of the complaint, and then she states the factual background. She talks about the defamation action and judgment for the claimant. And if you look at the link to the full video in our show notes, you will see that we did a full video that went over the litigation of Cardi B against this YouTuber, and Cardi B was awarded $3.8 million by the jury. As a result of debtor's malicious and intentional campaign to damage and destroy Ms. Almanzar's, Cardi B's, reputation among her fans and consuming public, not to mention debtor's efforts to monetize the defamation for greed and spite, on March 21st, 2019, Cardi B commenced an action in the District Court for the Northern District of Georgia, the Georgia District Court, against the debtor and Keep Studios, among others, in the case styled Belcalis Marlanis Almanzar, which is Cardi B's full name, versus Latasha Transrina Keeb. and then they have the case number. On January 10th, 2022, the Georgia District Court commenced a jury trial lasting multiple weeks in which the jury ultimately found debtor and co-defendant Keeb Studios liable to Ms. Almanzar for defamation, invasion of privacy, false light, and intentional infliction of emotional distress, and further found the debtor to be jointly and severally liable for the damages with co-defendant Keeb Studios. As a result of the jury verdict, on February 17, 2022, the Georgia District Court entered its judgment, the original defamation judgment, in favor of Cardi B and against the debtor and Keeb Studios. So the next page of Cardi B's complaint goes on to state that on July 19, 2022, the District Court for the Northern District of Georgia entered its amended defamation judgment, pursuant to which the District Court awarded $1,025,000 for pain and suffering and reputational damage and for medical expenses against defendant and Keeb Studios jointly and severally, $1 million in punitive damages against defendant and $500,000 against Keeb Studios, and $1,338,753.47 for litigation expenses against both defendants. On August 22, 2022, Ms. Almanzar initiated garnishment proceedings in Gwinnett County, Georgia. On March 21st, 2023, the 11th Circuit Court of Appeals affirmed the Georgia District Court's amended defamation judgment. On April 4th, 2023, $9,304.81 was garnished from Google LLC, representing debtor's income for her YouTube channel. An additional $1,083.02 was garnished from Chase Bank. However, the garnished income was not distributed to Ms. Almanzar and remains in the trust account of Ms. Almanzar's state court counsel, Daniel T. Silos. On May 25th, 2023, in furtherance of her efforts to hinder, delay, and defraud Cardi B's collection efforts, the debtor filed the above-captioned bankruptcy case, even though she knew at the time that the amended defamation judgment was non-dischargeable. Worse, the debtor continues to live her life in luxury. So Cardi B is saying that this debtor is continuing to live her life in a state of luxury above her means. For example, in the post-petition period, the debtor and her husband moved into a more expensive apartment compared to their pre-petition residence with a monthly rent of approximately $7,000. Additionally, the debtor's social media accounts showcase her wearing what appears to be high-end clothing, handbags, and jewelry. Plainly stated, the debtor continues to evade accountability for her willful and malicious actions against Cardi B, maintaining a luxurious lifestyle without making any payments towards the amended defamation judgment. In contrast, Ms. Almanzar has been compelled to incur substantial expenses to enforce the judgment, safeguard her rights as a creditor, and uncover the debtor and her husband's concealed assets and false testimony given under oath. Debtor and her husband hinder, delay, and defraud the claimant's collection efforts. On January 25th, 2022, after reading the jury verdict at the conclusion of the Georgia defamation action, the federal district court admonished debtor and her husband not to transfer their assets or otherwise change their financial condition. The court stated, I want to say this to the defendants. You have, this is a very substantial verdict that has been rendered against you, and your ability to satisfy it is independent of the fact that it exists. I would just caution you, not knowing what may have been transcribed, what may have been transpired before today, or what actions you may have taken. But I would caution you about any alterations of your finances or changes to your financiers in an attempt to try to make the judgment less collectible than it is. Under Georgia law, efforts to do that can constitute fraud and can subject you to an additional tort claim and or lawsuit, much less an effort that could be brought against in this court to enforce the judgment as it is to set aside actions that you may engage. And given that both of you, at least tangentially, are involved in this case by transferring assets, if that were to happen, and I have no information to suggest that you would do that, but defendants sometimes do, into the names of third parties, could also subject them to also possible tort actions in the future. Debtor and her husband knowingly disregarded the court's admonition. They spent thousands of dollars hiring multiple asset protection professionals to facilitate the transfer of assets and the establishment of both onshore offshore trust designed to place their assets beyond the reach of Cardi B. This is very serious, the allegations. These are very serious allegations that Cardi B is alleging. She's saying that debtor and her husband provided false testimony under oath regarding the existence of the partnerships and onshore and offshore trusts and deliberately concealed their existence from parties and interests in this court. In addition, the debtor knowingly lied when untruthfully answering no in paragraph 25 of Schedule AB when answering whether she owned any trusts. This false statement was not corrected until June 14, 2024, an entire year after the petition date, when it was addressed in an amended filing made necessary because Ms. Almanzar independently uncovered the existence of the previously undisclosed partnerships and onshore-offshore trusts. So the next page of Cardi B's complaint goes on to state, oh, and she's bringing out the receipts. She's quoting to the transcript. She's saying, the debtor and her husband, Mr. Keeb, admit moving debtor's assets to avoid the defamation judgment and the garnishment of their wages and assets. Cardi B states that over the course of multiple 2004 examinations, debtor and her husband testified untruthfully numerous times and plainly contradicted each other's testimony. But debtor and her husband were at least consistent when they both testified that they moved assets in an attempt to avoid collection of the amended defamation judgment and garnishment efforts by Ms. Almanzar. With respect to debtor transferring assets out of her name since 2022 to avoid garnishment, she testified, that's exactly how I meant it. Since you were sued, have you been taking assets out of your name? Objection. The witness says, since 2022, yes. Okay, and why have you done that? Objection. Witness, to keep my funds from being garnished and not being put out on the street. That's the 2004 examination of Latasha Keeb, who's the YouTuber who has had a judgment for $3.8 million entered against her. She owes Cardi B that money, according to Cardi B, and according to the jury verdict and the judgment that was entered in the case. With respect to debtor's transfer of the ownership interest in the Georgia property, Mr. Keeb admitted that the transfer was made to avoid garnishment. Question, and they're citing the testimony. Why did you wire transfer her interest in the Georgia property to you? Answer, I guess to prevent garnishment. I don't know. I think you do know, sir. I think you do know. And then they're also citing from the examination of her husband, Chiefney Keeb, from September 11, 2023. Question, regardless of whether you knew about the transfer at the time, there did come a time when you found out that your wife had transferred her interest in the Georgia property to you, correct? Answer, yes. Mr. Lieberman, that's the attorney, says, same objection. Give me a second. Mr. Moon, the opposing attorney, and the questioner said, and you didn't do anything to reverse that transfer when you found out, did you? No. And you didn't do anything to reverse the transfer because you wanted to help her avoid garnishment, didn't you? Mr. Lieberman, objection, calls for a legal conclusion. Mr. Moon, you can answer. The witness says yes. And that's from the 2004 examination of Mr. Keeb, September 15th, 2023 transcript. With respect to payroll payments for debtor that were being paid into Mr. Keeb's personal bank account to avoid garnishment. So this is the YouTuber's husband, Mr. Keeb. The attorney asked him, why are you making payments to Latasha into this account that's only in your name? Answer, to prevent garnishment. So her husband, Latasha's husband, is outright admitting that they were trying to evade having to give Cardi B money that's owed. They're trying to prevent having their wages garnished. The debtor further testified regarding payments for debtor going to Mr. Keeb's personal bank account. Question by the attorney. Okay, if I were to tell you that your husband testified that payroll payments from Yellen are being paid to you into the Bank of America account with your name off of it to avoid garnishment, would that be a correct statement? Objection. The witness says, probably, yeah. That would be a correct statement because I have the checks that he did write because I didn't look, Mr. Moon says, okay, and if your husband testified that he stopped making payments to you because you told him to stop so it could avoid being garnished, would that be a correct statement? Objection. And Latasha says that would be pretty correct. Oh my. With respect to debtor taking her name off the Joint Bank of America account, so now she's taken her name off of different accounts to avoid garnishment. The attorney asked her, question, and you also took your name off of the Bank of America joint account that you had with your husband, didn't you? Natasha says, I did. Well, why did you do that? Because it was going to get garnished, too, after they did the Chase account. With respect to debtor's funds that she was trying to keep from being garnished, the debtor testified. The attorney asked her, so how was he paying for your share of the rent? Objection. And then Latasha said, because he was managing my funds that were coming in that I was trying to hold from being garnished. Mr. Moon says, and those were the funds that were being held at Yellen Entertainment. Yellen Entertainment is her husband's company, correct? And then Latasha answers, correct. Mr. Keeb testified that the debtor directed him to stop making payments to her to avoid garnishment. Question, so did she tell you to stop paying her? Yes. Next page. Okay, and that was so you could prevent it from, or she could prevent it from being garnished, correct? Yes. Mr. Keeb admitted that he was assisting the debtor to avoid paying the defamation judgment that Cardi B has against the debtor through garnishment. Question. So you understand your wife was trying to avoid paying my client through garnishment, don't you? Objection calls for a legal conclusion. Cardi B's attorney says you can answer. Because in a deposition, even though there's objections, you can there's no judge there. It's not a trial. The attorneys can instruct the witness to answer. And so the debtor's husband said yes. And then Cardi B's attorney said, and then you were helping her to do just that, weren't you? Objection calls for a legal conclusion. Cardi B's attorney says you were helping her to avoid paying my client, correct? And the debtor's husband says yes. Mr. Keeb admitted that he was holding money for debtor's business to avoid garnishment. When you say that you were holding money for Unwind with Tasha K, were you holding that money to avoid the garnishment from Cardi B? Yes. He answered yes. And on the next page, as we continue this legal examination, he says, Yellen was managing the money still. Yes. Question. And Yellen was holding the money for you and your wife to avoid garnishment, correct? And the husband of the debtor says, I think I have already answered that question many times. And the answer is yes, correct? Yes. Yellen was holding Tasha's money, and Tasha was asking Yellen to manage her money, and they paid towards her bill. And Yellen was holding that money to avoid the garnishment, correct? Yes, and pay her bills. Mr. Keeb testified that Yellen was paying the debtor's business debts to assist the debtor in avoiding garnishment. And you mentioned before that Tasha K on stage is just your wife's business, correct? Yes. So why is Yellen paying this amount to Flamingo Theater? Yellen is producing it and managing Tasha K funds to produce it. And this went on October 20th. It's like the comedy show in Atlanta in March, correct? Yes. Why is it that Yellen would be paying for this event now when Tasha individually was the contract party in March? It was launched before Yellen was managing Tasha's funds, so Yellen was paying for it. Again, Yellen is managing Tasha's funds to avoid garnishment, correct? Yes. At his 2004 examination, Mr. Keeb was asked about the accuracy of a chart prepared by Cardi B's forensic accountant, Barry Mukamal of Kapila Mukamal. The chart was based on financial documents provided by the debtor, Mr. Keeb, for Keeb Studios and Yellen, and demonstrated that in August of 2022, the same month the Georgia State Court garnishment action against the debtor commenced, income previously directed to Keeb Studios, which was Tasha's business from various sources, ceased and was instead directed to Yellen, which was the husband's business. So they're showing diversion of assets. Okay. So then this shift was consistent with efforts by debtor and Mr. Keeb to circumvent the garnishment of debtor's income. Question by Cardi B's attorney. And if we keep going, you see that all of a sudden, and it looks like August of 2022, Tasha K income that had been going into her business, Keeb Studios, stopped and then shifts over to Yellen, which is the husband's business, doesn't it? The husband says yes. And then it keeps on tracking until May 2023, correct? Yes. So when you look at the chart like that, you can see that it is pretty clear that the Patreon money stopped, and then all of a sudden, Tasha K Live started right after that. You see that? Right. Yes, I do. Yes. You also see that in August of 2022, Keeb Studios all of a sudden stopped getting any money coming for Tasha K Live money, and then it starts being funneled into Yellen, correct? Yes. And this is consistent with what you told us before, which is that income was being moved to avoid garnishment, correct? Yes. In summary, the debtor and Mr. Keeb blatantly disregarded the Georgia court's admonition and orchestrated a deliberate scheme to hinder, delay, and defraud Cardi B, preventing her from collecting on the amended defamation judgment. Next page. Cardi B's complaint goes on to state that notably, Yellen became a central instrument in their fraudulent activities. So Yellen is the company of the debtor's husband. The sworn testimony of debtor and her husband clearly reveals how they strategically moved income beyond the reach of debtor's creditors by transferring all business operations from Keeb Studios, a co-defendant and judgment debtor jointly owned by debtor and Mr. Keeb, to Yellen. As detailed above, this maneuver was admittedly aimed at evading Keeb Studios' liability under the amended defamation judgment. Debtor and her husband conceal and testify untruthfully about evidence of onshore offshore trusts. So unfortunately, neither debtor nor her husband have been truthful regarding the existence of both offshore and domestic trusts created for them. Specifically, debtor's schedules in the bankruptcy do not reveal the existence of any trusts. So then Cardi B's attorneys have some screenshots of the questions on the bankruptcy petition about whether there's ownership of trusts. And they, as you can see, they checked the box that said no. There's two places where they said no, no. And guys, I ask you, if you're getting value from the stream, if you'll hit the subscribe button, because we do come live to you every day for daily live streams and show you real legal pleadings in celebrity legal cases. So then Cardi B's complaint goes on to state, during the 341 meeting of creditors, the debtor was questioned about the existence of any trusts. And this is the 341 is a meeting where all the creditors have the opportunity to be present. So then the Cardi B's complaint goes on to quote some additional paragraphs from her attorney's questioning of the debtor and her husband. Cardi B's lawyer says, and with respect to deposits of money, you mentioned that you have one checking account. Do you have any savings account or any IRAs or any trusts, say, for example, for your children? No. You don't have any trust set up for your children? No. At her 2004 examination, that the debtor further disclaimed the existence of any trusts. Cardi B's lawyer said, you never told anyone that she was never going to get money because you have your money in trusts. Answer, no, I don't even have trusts. That was from Ms. Latasha Keeb. Not only did debtor disclaim the existence of any trusts, but the debtor also specifically acknowledged that she and her husband knew they could not create trusts because of the defamation action. Question, and you mentioned you had estate lawyers. Answer, no, I ain't never had. The only estate lawyer we had was the one that made not the trust, but the wills. And I'll give you her name and the power of attorney in case something happened to us. So they're claiming they never had set up any trusts. They only set up wills for if something happens to them. Then Cardi B's attorney asks, is there any kind of trust? And they said, no trust. Have you ever tried to start a trust? No. I mean, we talked about it, but we didn't do. We was advised, like, because we were in the middle of a lawsuit, that we couldn't do that. When you say we, who is we? Me and my husband and that lawyer that did life insurance and all that stuff. Debtor's husband, Mr. Keeb, likewise testified untruthfully that there were no trusts. Okay, do you have a trust? No. Do you have a trust for your children? No. Do you know that your wife has publicly talked about the trust that she created for your children? We thought about it, but you never did it? We don't have one. So that was Mr. Keebs. So during the course of discovery in this case, despite debtor and Mr. Keebs' intentionally untruthful testimony, Cardi B has uncovered the existence of partnerships and multiple domestic and offshore trusts that were not disclosed, and payments of approximately $25,000 to set up an international asset protection plan. Oh my gosh. So they were really trying to avoid assets, it looks like, if these allegations are true. Specifically, the debtor failed to disclose the existence of or testify untruthfully about the following: the Simbasasi Investment Trust in Cook Islands, the Saninkis LLC, Island of Nevis, the Bamako Trust, Keeb Children, ILT in Georgia, the Transrena Management Trust, Georgia, Florida Joint Revocable Living Trust, and Tanton Limited Partnership, Georgia. When confronted with undersigned's discovery of the undisclosed Tantu Limited Partnership Transreni Management Trust, Mr. Keeb feigned ignorance of their existence, who owned them, and what interest he may have in them. So that's, all right, so moving forward, they said specifically Mr. Keeb first testified that he had no interest in Carolyn Homes LLC, a company for buying and flipping real estate, and that it was his wife's company. Cardi B's attorney asked, question, is there any other type of business that you conducted through Keeb Studios? So film production or the management of Unwind with Tasha K. Yes. What was that? It was Carlene Home and Mollify, I believe. You conducted those through Keeb Studios. It was financed by Keeb Studios. Next page, continuing the examination by Cardi B's attorney, states, they were financed by Keeb Studios? Asked her attorney. Yes. Aren't these, well, correct me if I'm wrong, but aren't these businesses that your wife owns? Yes. Do you have an interest in either Carlene Homes or Mollify? No. And I got that right. Carlene Homes, and Mollify. Yes. At his examination on October 16, 2023, Mr. Keeb changed his testimony from September 11, 2023. What is Carolyn Homes? Carolyn Homes was one of the businesses that my wife and I had. So you and your wife had it? Yes. What was it a business for? It was to invest in buying homes and flipping them. So he changed his story. He first says it was something his wife owns. Now he's saying it's something they own together. So next, on the next page, continuing this examination, why did you testify on September 11th that you did not have an interest in Carolyn Homes? Because Carolyn Homes and Wollify was the last thing that I heard. You are saying that you didn't hear Carolyn Homes. Wollify is what I recall hearing. So you are changing your testimony today as well, correct? Correct. And you did have an interest in Carolyn Homes, correct? Yes. Even though Mr. Keeb changed his testimony to state that he owned Carolyn Homes on a 50-50 basis with his wife, the Articles of Organization for Carolyn Homes reveals that Tantau Limited Partnership, another undisclosed entity of debtor and her husband, is the organizer and authorized signatory for Carolyn Homes. Unironically, Tantau is the name of the Keeb's daughter. Moreover, the Certificate of Limited Partnership of Tantau Limited Partnership reveals that the general partner of Tantau Limited Partnership is the undisclosed Transrena Management Trust. Despite admitting to owning 50% of Carolyn Homes, Mr. Keeb was unable to provide details regarding who maintains the books and records of the company. Furthermore, he could not offer information about the creation, existence, or ownership of Tantau Limited Partnership or Transrena Management Trust, aside from referencing estate planning attorney Natalie Green Hosea, whose communications are presumably protected by attorney-client privilege. Although sometimes, friends, I've seen in cases that I've worked on, when a defendant is claiming attorney-client privilege, and they're saying I acted on the advice of counsel, then that waives the privilege. Some states rule that waives the privilege, because you can't say, oh, I was just following my attorney's advice. I was advice of counsel, but then never be accountable for it. If you're blaming your attorney, if you're saying, well, I was just following advice, some courts have ruled that waives the attorney-client privilege. So then Cardi B's attorney goes on to question and say, who owns Tangerina Management Trust? I don't know. You don't know? I don't know. Does the word Tangerina maybe give you a clue as to who might own it? Tangerina? Tangerina is my wife's middle name. Do you recall that you testified that there were no trusts, that neither you or your wife owned any trusts? Yes. So why are we seeing Tangerina Management Trust here for Tantal Limited Partnership as the general partner? I don't know why. Who were the limited partners of Tangerina Management Trust? I don't know. So this is some very inconsistent testimony. He's kind of disclaiming all knowledge. Are you a limited partner in Tangerina Management Trust? I don't know. Are you a limited partner in Tantal Limited Partnership? I don't know. Who would have documents related to Tantal Limited Partnership? That would have to be the attorney. Natalie Green Rosea? Yes. That Tantal Limited Partnership is still an active partnership, isn't it? I don't know. Who would have the books and records of Carolyn Holmes? Books and records of Carolyn Holmes? I don't know. You don't know? I don't know. So that was from his examination on October 16, 2023. These examples represent just a fraction of the deceptive and blatantly false testimony provided by Debtor and her husband throughout this case. Nevertheless, they clearly demonstrate the premeditated efforts by Debtor and her husband to shield assets from their creditors, specifically Ms. Almanzar, also known as Cardi B. Next, we talk about the legal background in this case. The legal background, the outline section 1112B of the Bankruptcy Code, talking about a Chapter 11 bankruptcy. They talk about the intent of a bankruptcy, the purposes behind a bankruptcy, and in conclusion, they state that claimant respectfully requests an order of the court dismissing the debtor's bankruptcy case with prejudice to the filing of petition under any chapter of the Bankruptcy Code for a period of 2 years from the date of the order of dismissal, or alternatively converting the Chapter 11 case to a case under Chapter 7 and granting such other and further relief as the court deems just and proper. And then Cardi B's attorney, James C. Moon, in Florida, signs off on this pleading. Then, if we want to go through, we can look at the exhibits. This shows the electric filing. A lot of things now are electronically filed. These are some of the exhibits that they were referencing, because you can attach proofs to your complaint. Some of this is redacted, because when you're filing in a public filing in the legal system, there are certain things that are required to be restricted from public access. Some of which include like social security numbers, driver's license numbers in some states are protected. Other times, certain things that are in family court or other types of court proceedings are protected and restricted from public access. Sometimes health insurance numbers or bank account numbers are sometimes restricted from public access. So that's some reasons why some of these exhibits may have some redactions on it. But these are the proofs that Cardi B's attorneys have attached to her complaint that she has filed, asking the court to dismiss the Chapter 11 bankruptcy case of Tasha K, the YouTuber who was slammed with a $3.8 million judgment and jury verdict, and therefore owes Cardi B $3.8 million. The lawsuit is covered in a full video that we did. That's linked in the show notes in our description box below. We did a full video on that. So friends, thanks for tuning in. Subscribe to our channel for daily live streams on celebrity legal battles. We're covering the Angelina and Brad Pitt continued litigation over Miraval. We're covering the Vanderpump Rules litigation between Rachel Leviss, Ariana Madix, Tom Sandoval. We're covering the Sean Diddy Combs federal prosecution. He's going to a jury trial on May 5th, 2025. We're covering Jay-Z's lawsuits with Tony Busby, and Quinn Emanuel and Tony Busby's lawsuits going back and forth. We're covering all of Sean Diddy Combs' civil lawsuits that have also been filed, his criminal prosecution. Jay-Z's been brought into it now. There's a lot of going back and forth between Tony Busby and Jay-Z. We are also covering the Give Them Lala trademark infringement lawsuit that Lala filed against Cosmesi LLC, a New Jersey limited liability company. Tom Sandoval has announced that he's representing himself in the Vanderpump Rules litigation. So we are covering that, friends. So go through our live stream feed, go through our videos feeds. We're covering all of this every day with daily breaking news. I pulled all of the legal filings that have been filed on the dockets of these real cases of celebrities and entertainment figures, and I play them for you daily. I talk about them and give you commentary to break it all down for you. So friends, let me know in the comments what you think, and thank you so much for joining us here today live. I look forward to being back again live with you tomorrow. Have a great rest of your holiday weekend, and we look forward to seeing you. I just wanted to let you know we have just hit over 100 subscribers on our very young YouTube channel. We are a new channel. We have already hit almost 50,000 views, and we have our first 100, 101, 102. Thank you. We just got 102. We now have our 102nd subscriber, friends. I want to thank you all so much for all of the support, all of the comments that you guys have shared in, and you guys are so insightful. Thank you so much for sharing all of your comments, especially in the Sean Diddy Combs videos about Diddy's federal prosecution, about his civil suits, and also Jay-Z's civil suit, and the war that's going back and forth between Tony Busby and Jay-Z. You guys have had amazing comments, amazing engagement. I try my best to make sure that I respond to every comment to the best of my ability, because I want you guys to know that I do value you guys. You guys are the reason that makes this channel great. Your discussions, you guys being willing to share your opinions and thoughts is what makes this channel successful and growing. And I just want to thank you guys so much for all of that engagement and taking the time to share your views and and discuss it on our forum. Let me know in the comments what other cases that you'd like us to follow here and to report on the daily legal celebrity entertainment news. And thank you so much, friends. I'm signing off. I hope that you enjoy the rest of your holiday weekend. Have a great night.